Hi everyone, welcome to your first recorded PowerPoint on hearsay evidence in criminal cases. So this has been designed to be a short introduction. It's going to take you through the initial concepts about hearsay, what it is, the rule on using hearsay, and some case law examples. So by the end of this PowerPoint, you're going to be able to identify the three elements of a hearsay statement. You're going to know what rule of evidence hearsay falls under. You're going to be able to examine the rationale behind the hearsay rule and distinguish hearsay from original evidence. At common law, hearsay evidence was first defined in the case of Sharp in 1988. And the definition was an assertion other than one made by a person while giving evidence in the proceedings is inadmissible as evidence of any facts asserted. So essentially what that definition was saying, that a statement that's made by somebody other than that person that's in court proceedings is inadmissible as evidence. Now, the rules governing hearsay were put in statutory form, and in the Criminal Justice Act 2003, you have section 114, subsection 1, which provides for the current definition. And that is that in criminal proceedings, a statement not made in oral evidence in the proceedings is admissible as evidence of any matter stated, if, but only if. So now, whilst hearsay is admissible, it is only admissible if one of the exceptions applies. And we'll go into that in more detail in the lecture. So essentially, from that 2003 definition, we have three elements to a hearsay statement. So the first is that you need to have a statement, and that statement needs to be made by a person. The second is that the statement is made out of court, and the third is that the statement is tended to prove the truth of that statement's contents. Now, it's important to remember with hearsay that not every out-of-court statement is going to contain those three elements. There are some statements which, if relied upon in this context or one context, would amount to a hearsay statement, but if relied upon in a different context, they wouldn't amount to a hearsay statement. So to have a statement that amounts to hearsay, you need those three elements in red. Now on the screen, you'll see two boxes that are in purple. So for example, an out-of-court statement, so you have a statement made by a person, made out of court, but that's tended to prove something other than the truth of its contents, that would amount to original evidence. So there's a distinction between the two. And in your handout, you'll see you've got that distinction in two orange boxes. But what we're concerned with here is hearsay statements. So what we're going to be discussing for the next 3 weeks is the statement that's made by a person, made out of court, that's tended to prove the truth of that statement's contents. Let me give you an example which may help you. So in a road traffic accident, witness W told another person, X, that at the time of the accident, the offending car was blue. Now, in court, it's necessary for the prosecution to prove that that car was blue. So they call witness W. Now, if witness W was available and could come to court to give evidence of what they saw, then that would be great. There wouldn't be a problem. However, on this occasion, witness W is not available. And the prosecution want to call X to give evidence of what W told them. So in this context, what we have is a statement made by W that's been made out of court and is being brought into court for the purpose of proving the truth of its contents. And its contents was that the offending car was blue. And the prosecution want X to come to court to tell the court, that the offending car was blue. So X is coming to court to give evidence of what W saw. In this context, this would amount to a hearsay statement. And because it would amount to a hearsay statement, it's inadmissible unless one of the exceptions under section 114 applies. Now, we've just spoken about the distinction between hearsay evidence and original evidence. If, for example, the prosecution wanted to rely on the statement made by W to X to prove that the driver of the blue car spoke with a French accent, for example, then this wouldn't amount to hearsay. It wouldn't amount to hearsay because although you have an out-of-court statement made by a person, it's not being adduced to prove the truth of its contents. It's being brought into court to prove the truth, to prove something else. So the fact that the car was blue is irrelevant. The prosecution want to use the statement to prove that the driver of the car spoke with a French accent. I hope that helps a little bit in showing you the distinction between hearsay and original evidence. Essentially, what you need to understand are the three components which we have here, those three elements of what amounts to a hearsay statement. Now, hearsay is an exclusionary rule of evidence, which means it's inadmissible unless an exception applies. Now, if you remember back to that definition that's found in section 114, subsection 1, the out-of-court statement tendered to prove the truth of its contents is admissible if and only if, and that if relates to one of those exceptions being applicable. Now, there is a rationale behind hearsay statements being part of an exclusionary rule of evidence. They're not considered generally to be best evidence. It's much better to have the person that witnessed the event come to court and tell the court what they saw. Now, the reason it's not thought of, or hearsay is not thought of to be best evidence, is because there's a risk of distortion or concoction. The statement, for example, if we go back to the car accident and W and X, the statement that W made to X could be taken out of context. It could be overemphasized. It could be changed in some way. And there is always a risk that where X comes to court to relay what W said, that the facts would be distorted or something could be made up because they didn't directly see or witness what has happened. Now, one of the most powerful rationales behind the exclusion of hearsay evidence is that the witness is not available for cross-examination. So, for example, going back to the car accident, if X comes to court and tells the court what W said to them, they cannot be cross-examined because they didn't see what W saw. They might not have been there at the time, or they might have been looking the other way. Also, hearsay evidence isn't delivered under oath. And the demeanour of the person that made that statement, so W, who made that statement to X, and who allegedly saw what took place, cannot be shown to the court. So there is a good reason why hearsay statements are part of an exclusionary rule. So the nature and the scope now of the hearsay rule is contained in section 114, subsection 1 of the Criminal Justice Act. You've got the definition there. And if and only if one of the paragraphs under section 114, subsection 1A to D applies. Now, in the lecture, we will be going over those exceptions and what they mean. There is quite a lot of case law attached to those exceptions that has been derived over time. So, some examples of hearsay statements. In Patel and the Comptroller of Customs, the words produce of Morocco were inadmissible hearsay because the prosecution wanted to use this written statement to prove that it was true. They wanted to adduce the statement to prove that the seeds were from Morocco. Another example can be found in Jones and Metcalfe, and this is very similar to the road traffic example that I gave earlier. And the police officer was called to give evidence of witness W, what witness W had said, and that was in relation to the registration number of the lorry. Now, you'll see in this example and the previous one, the terminology inadmissible hearsay is used. And that's the terminology that you need to get used to. Because hearsay is part of the exclusionary rule of evidence, it's referred to as being inadmissible hearsay unless one of the exceptions to the rule applies. Now, in your handbook, you have other examples of hearsay statements, and you've also got hearsay statements that have been adduced to prove identity. As I said, this PowerPoint presentation is designed to complement that introductory handout that you've got and to provide you with a very brief overview of the subject matter before you come into the lecture and we discuss this further. So just by way of a very brief recap, hearsay is an exclusionary rule of evidence. So that means it is inadmissible unless one of the exceptions apply. The Criminal Justice Act 2003 contains the rules relating to the use of hearsay. They are now in statutory form, although there are some common law rules which are still relied upon, which we will discuss in next week's lecture. There are 3 elements to a hearsay statement, and hearsay can be distinguished from original evidence. So what's next? So in the lecture, you will have a brief activity about your understanding of what amounts to a hearsay statement. And then what we will do is discuss some of the exceptions to the exclusionary rule of evidence relating to hearsay in criminal cases. Do go over your introductory handout. Do have a listen to this another couple of times if you're still not sure about those hearsay evidence. If you're still not sure about what amounts to a hearsay statement. But above all, don't worry about it. When we go through the exceptions in the lecture, things will start becoming clearer. And when we start doing some of the practical work, solving the problem that you're going to be given, I am absolutely sure you will start understanding what hearsay is and what it amounts to. Okay, thanks very much, and I will see you in your lecture.